Again, for those of you who are just joining us, my name is Michael Stewart. I'm the Director of Education at the OI Foundation. We are very excited for today's call on employment accommodations and COVID-19, understanding your legal rights during the pandemic. This is a topic that is really close to us personally, and we think is very important to our community, to all of you. I am really excited today to introduce our speakers today. We have two real experts on this call who will be presenting today, and then we'll have being followed by a Q&A afterwards. If you have any questions during today's session, please type them in to the Zoom chat, and we will have a designated Q&A time at the end of today's call. So again, if you've ever been on a Zoom call, you see the little chat bar at the bottom bar, and you'll be able to type in a question and we'll answer them as soon as we can. So today's speakers, first I want to introduce Gary Phelan. He's an attorney and law professor whose specialties include disability discrimination, employment discrimination, and wrongful termination. He has written on these topics in multiple publications and has appeared as a commentator on ABC's Good Morning America, CNN, NBC Nightly News, CBS This Morning, CBS Evening News, Fox News, Court TV, and MSNBC. Gary, thank you so much for being with us today.
Thank you for inviting me.
And also we have Michelle Duprey, a longtime OIF community member and past board member. Michelle is an attorney, OI community member, and past board member. She's been practicing the law, focusing on employment matters for more than 25 years. Currently, she oversees the ADA compliance for the city of New Haven, where she is responsible for reviewing and implementing all disability-related accommodation requests for employees, job applicants, and the public. She's a frequent speaker on disability-related policy and employment matters and has written many articles related to ADA compliance. Michelle, thank you so much for joining us today.
Thank you.
And with that being said, I'm going to hand it off to them and let them jump in. So thank you both so much.
Thank you. I'll just quickly jump in here and say that thank you to the foundation for hosting us today. And I want to make sure everybody understands that nothing in this presentation can be considered legal advice for your particular circumstance. It's merely informational. And if you have a particular issue or a question in which you do want specific legal advice, there'll be some resources at the end of the presentation for you to contact to get that advice in your particular circumstance. And also remember that some states grant more rights to people with disabilities than the ADA, which is a federal law, which covers everyone, but every state may be slightly different. So check your local state rights. So with that, I'll let Gary get into the Americans with Disabilities Act.
Okay. I thank you all for the opportunity to speak to you today. My name's Gary Phelan. I'm going to be talking about just kind of the basic elements of the Americans with Disabilities Act. The three basic elements are the definition of disability, whether or not somebody is qualified to do the job. So qualified is the key term. And then the third is reasonable accommodation. So with respect to definition of disability, it's a three-part definition. If you meet any of these prongs of the ADA, you're considered to have to be a person with a disability. Why that's important is unless you have to have a disability in order to be entitled to a reasonable accommodation. Now, Michelle is going to be talking more about just the specifics of OI and whether or not it meets the criteria for a disability. But the basic definition is physical or mental impairment that substantially limits one or more major life activities, a record of such an impairment, or being regarded as having such an impairment. Just to address the third part is the regarded as is somebody may not have an impairment that meets the definition of disability, but the employer, based on their actions, based on a stereotype, based on fear, may treat them as if they do. What's important to keep in mind is if somebody doesn't have a disability, but is regarded as having a disability, they're not entitled to a reasonable accommodation. How it relates to what we're talking about is that, as certainly we all know by now, somebody who has an underlying medical condition may be more at risk, or not, it is generally more at risk of more serious consequences or death in the event if they contract COVID-19. So the first threshold issue after disability, definition of disability is the person qualified? Essentially, the person has to be able to show that they can perform the essential functions of the position with or without a reasonable accommodation. So, some of the examples we'll be talking about is, it's not just can you do the job. The sort of linchpin of the whole definition is reasonable accommodation, which we'll be talking more about. The essential functions is the major job task which a person must be able to perform to be able to perform the job. An example I use when people call me is potential claims is really to outline what it is they can't do. For example, the example I use is if somebody has a severe visual impairment and they applied for a job as a bus driver. They can't perform the essential functions of the job because their impairment prevents them from doing so. The essential functions is not necessarily an easy, clear-cut what is and isn't, an essential function. For example, one of the things you look to, though, first what the employer thinks is essential. Another may be whether or not there's a job description. That also will be helpful with respect to determining what are the essential functions of a position. Okay, on to reasonable accommodation. And just to make sure I don't forget, a very valuable resource in analyzing and looking at job accommodations of any kind is what's called the Job Accommodation Network, which if you Google that, you'll see it's free. It's something that's actually funded by the federal government. I think it's at West Virginia University is where it's based. They have a wide resource of accommodations they've used, over really the ADA was passed 30 years ago. So there's a kind of a wealth of experience, what works, what doesn't work, and it's all available on the website. Now, with respect to reasonable accommodation, as it relates to COVID, the primary accommodation that has been utilized over the past, now coming up to 7 months, has been working from home. But the first thing to keep in mind is, not all jobs can be performed at home. Based on, studies that have been done, the estimate is about 40% of positions can be done remotely. It's and a lot of the other 60% really, are where they're the tougher issues with respect to accommodation. Now, before COVID-19 happened, certainly I know I represent a lot of individuals seeking working from home as an accommodation. And so we're working remotely. It's something that has, probably, the estimates about 2/3 of courts have said, no, working from home is not an accommodation. A lot of it is, the kind of the determinations, because what the EEOC says, provides basic guidance and says the employer may be required to provide to permit someone to work from home as long as they can perform the essential functions. But there's been a variety of roadblocks with respect to that setup. And also important to keep in mind, the law is really determined by federal judges who are, as well as state court, but primarily with ADA federal judges, who aren't exactly digital natives when it comes to, technological innovation and advantages. And so, you'll often hear in some of these cases where courts said, no, working from home in that particular circumstance is not a reasonable accommodation, is that, sort of teamwork and being together is an essential function of any job, even if it's not in the particular job description. Now, so we're, on the other hand, there are certainly some courts that are more progressive. There also have been cases where somebody just genuinely is not able to do the job, even working from home. Things changed obviously back in March, particularly with the various shutdowns that were required, sporadically throughout the country. And that's where working from home became more, kind of a part of the just general work process, because to a large extent, unless somebody was an essential worker and had to be, actually physically on the job, if people were working, they were working from home. And so I think it's something that's become more a part of the fabric of the workplace. A lot of employers, often more technologically advanced employers, are seeing the benefits of working from home, reducing their footprint, their, lease costs. So I think this is going to be a trend that's going to continue now that, gotten over sort of the element of change, because it's become more of an acceptable way for people to perform work. That said, there's still a pushback, in the workplace, even where people have been working from home. A lot of times people assume that, well, if I was working from home back in March, April, and May, obviously I can continue to work from home. First, they have to have a disability in order to be able to work from home. Generally just fear, if somebody doesn't have an underlying impairment, fear of contracting COVID in itself is certainly not a disability, unless it has something to do with, underlying psychiatric impairment. What the Equal Employment Opportunity Commission, they enforce the ADA. They went in and said that an employer's temporary shift to have all their employees working remotely during the lockdown does not necessarily mean that the company has to accept all remote requests in the future. Because I think they were responding to employers, because employers were getting employees saying, well, I did it before, why can't I do it now? So it doesn't mean because you did it before, you have to do it now. On the other hand, I think the argument is better. Not only because now there's the knowledge base, but if somebody was able to do their job from home in the past, I think it's now shifts the burden, and the employer really has to say, okay, well, if they could do the job back during the lockdown period, what is it about the job now that's different? That said, it's, you can't, you can't drive a bus from home. You can't cook. You can't, be a waiter at a restaurant, if working from home. So there's still going to be the basics of some jobs are going to be required physical presence. Okay, some of the, all alternative reasonable accommodations, and again, it all depends on the nature of what the job is, but they may involve things like physical changes to the workplace, temporary transfers to another position. So, for example, if there's not as much, or there's no or very limited contact with the public, leave of absence, although I don't think that is necessarily as effective here, even though it's something that's often utilized with the ADA, because in this case, due to the uncertainty of how long, things will change when a virus, or when we get, I should say, a vaccination. Modified work schedules, again, that can often be something to enable someone to work on a less, where there's less face time with clients or customers. Plexiglass is something that's also, being utilized, but also just make sure that it's not just, that there's a base of four. For example, in our law office, we have plexiglass, but it goes up to the ceiling. I've heard some people saying unless it goes to the ceiling, it's really just, it's not real particularly effective. Shifting assignments or transferring non-essential functions if they really are, not essential to the job. And just for a quick segue, we'll be talking later about, essential functions and non-essential functions sound like, but have nothing to do with being an essential worker and a non-essential worker. Part of the jargon that's kind of emerged during the COVID arena. So with that, I will turn it back to Michelle.
Thank you, Gary. I know a lot of the, I've had the job of processing accommodation requests for the city I work for, and we've implemented a lot of the accommodations Gary just described. And so I'd be happy to answer any questions related to that. But I want to talk now specifically about osteogenesis imperfecta and how it fits into the ADA structure. For all types of OI, one, we have problems with bone. One of the ways you can be considered disabled under the ADA is if you have a substantial impairment of a major life activity, which includes bodily functions. And in turn, for us, one of those could be bone growth. So OI affects our bone formation, growth, and metabolism. So under the ADA, I would make a strong argument that all types of OI fall under that for that reason. But also, particular to COVID, where we are much more concerned about being high risk, is for the initial research is showing that for all types of OI, our lungs are affected by the collagen defect. And for some of us, it's very similar to having COPD. But there are structural differences in all types of OI in our lungs. And so that could be another avenue for falling under the term disability under the ADA. OI can affect in some our heart valves. So given that emerging research in COVID is showing that some of the major problems people with COVID are having is related to vascular function, blood clots and blood flow and heart damage. We do have, some OIers do have problems with heart valves because they are made of collagen. So that may be a way that you are covered. Because there's collagen in blood vessel walls, that could be affected by your OI. Again, making you fall under disability and also maybe a reason why you want an accommodation. Most of us know that excessive coughing for someone with OI who catches COVID is going to break ribs at a minimum. And for some OIers, they can break a leg coughing too hard. So that is another reason to consider yourself highly susceptible to COVID. The other accommodations I would just want to mention is lots of us have hearing loss. And hearing loss due to OI means that you might need some other types of accommodations. For instance, your coworkers wearing masks that are see-through so that you can communicate with them. In my office, we have somebody with a hearing impairment, and although the office isn't isn't open yet, the plan is that we would provide coworkers with these masks that you can see through, and also software on her phone that when she's interacting with somebody who doesn't have such a mask, they dictate whatever they want to say into the app on the phone, and it comes out as text. So that's how we're accommodating her. And then many of us who live with OI have secondary conditions that make us high risk, even if your OI is mild. Things like asthma, hypertension, obesity, those are all going to put you at high risk for COVID, which would trigger wanting to limit your contact during these times. Unfortunately, as is all things with OI, you're going to have to educate your employer and your healthcare provider on the risks. Whether you're type 1 and people don't know you have a disability, you're going to have to, if you feel like you need an accommodation, you're going to have to educate the employer on what your particular impairment means for the workplace. You're also going to have to educate your healthcare providers, because many of us don't have OI experts as handy as the doctor down the street that we see for coughs and sniffles and things. So you may have to educate them on the particular risks COVID creates for somebody with OI. Employers are accustomed to health issues listed by the Center for Disease Control, also known as the CDC. They have a list of high-risk conditions. OI is not on that list. It's only about 10 conditions. It is very general. So you're going to have to figure out how you fit into that list. There used to be chronic lung condition was on the list, but it's been dropped. So you'll need to talk about the other ways OI could be impacted by getting COVID. And for some people with OI, like I said, lung function is similar to COPD, which still remains on the CDC list. So you could say, I know OI is not on that list, but it's just like having COPD. And the employer will see that it is on the list, and that you should be eligible for an accommodation. You may also have to explain the same thing to your healthcare provider if they're not so familiar with OI. So now we're going to talk about the accommodation process, and I'll let Gary kick it off, and I'll wrap up at the end.
Okay. As I mentioned before, the reasonable accommodation is really the linchpin of the Americans with Disabilities Act. It's what makes ADA really unique from any other law. It's really the only law that requires, essentially, I always say requires problem solving. Most laws are focused on what, not to do. Don't discriminate based on, race, age, sex, disability. But the ADA also uniquely requires them to provide a reasonable accommodation unless it gives rise to an undue hardship. And again, like much of the ADA, it's the application of those terms that's important. What I have found over the past 30 years, because in representing, advising people on reasonable accommodations and negotiating accommodations, is to really just apply basic problem-solving skills. What I have is kind of a list of the top 10 things I've learned, often through trial and error, over the course of that process, or when somebody comes to me where I think, they may have been the one responsible, for dropping the ball. And that's what courts have the Equal Employment Opportunity Commission, they didn't lay out, okay, here's how to go about requesting an accommodation. So, but what courts have done is to really say, okay, what's envisioned is a good faith interactive process. I think we have to keep in mind is, it's a good faith interactive process, but there's a wide disparity in bargaining power. So employees are on the side with the limited power, so they have to utilize what they have and do it effectively. But if things break down, what courts do is look at who essentially dropped the ball, who's responsible. Now, sometimes people request an accommodation. The employer just says no. Those cases are easy to figure out who dropped the ball. Even with that, it's not necessarily a violation of the ADA. The employee still has to show that whatever they were requesting is reasonable. So to go through the list and briefly describe why I say these. One is to put the request in writing. I think that and certainly it can be in combination with, say, if you really trust somebody, going to somebody, a supervisor, a manager, to talk about it first and then put it in writing. The reason I say put it in writing is because what I've had is where clients say, well, I asked them about this, either due to lack of memory or just dishonesty. Employers say, I don't recall. And the question always is, well, is there any record of it? So want to put it in writing. To skip down to the last of the 10 elements on the slide, though, is whatever you put in writing, write personal and confidential. The ADA, provides that any documents relating to any medical issues are to be kept confidential. There's no guarantee that they'll comply with that, but generally my experience has been they do. It's generally only released on a need-to-know basis. A need-to-know may be the head of HR, a supervisor, a manager. I can't guarantee any client this will absolutely remain confidential, even though the overwhelming majority of times it seems like it does. Any of the written communication always end with, let me know if you'd like to discuss it further. The reason is it's consistent with you want to be showing good faith, regardless of what the employer is doing in response. You want to show, that you are willing to negotiate, you are willing to be flexible, and that you didn't take a hard line. Also, persuade, don't threaten. And it's consistent with what Michelle was talking about is really the need to educate. Because I have sometimes gotten involved where I see the communication and maybe email 2 is, you're required to do this under the ADA, and if you don't, I'll sue. That's not a good problem-solving approach. It may end up that, but let it be where you've shown on paper, particularly, that you've made every good faith effort to try to reach a resolution. Also, some employers, if it's done aggressively and saying like you have to do this, because under the ADA, it's ultimately the employer makes the decision of what, if any, accommodation is provided. That's why I also say be respectful, be patient, and most importantly, be tolerant. Inevitably, you're dealing with people who are maybe clueless about the nature of impairment, who are skeptical, and so it really requires being tolerant with whoever you're communicating with. Include a letter from a physician. I think that always helps. If not initially, then certainly make the offer to do that, but also discuss it with the physician. What has been, I think, the biggest problem I've seen is physicians who, kind of are old school, will scribble something on a piece of paper, Joe can't work. How long? Indefinite. And so it's tough telling my client their doctor just basically torpedoed their case. So really work with in advance of them writing something, and to at least give some, more concrete ideas, but I don't know what it is about the medical profession and handwriting, but ask them to just write neatly so that it can be read. The also, because I know there was a question about how much information do you have to provide. You have to provide enough where there's the basis for not only that there is a disability, but that what it is about the requested impairment that will enable the person to perform the essential functions of the job. There's no fine line between what you do and you don't have to disclose. I always recommend to clients, if you're going to err on the side of too much information, because if it ends up in a claim, courts say, well, there was confidentiality. They asked them to provide it. The employer refused or provided some but not all. And therefore, they are the ones who are perceived as having dropped the ball. Also, and just as Michelle was saying, is that to provide educational material is important. I've had clients provide, even just something off the internet about the nature of their impairment, something about accommodations from the Job Accommodation Network. Keep it simple, straightforward, because it can help start a discussion. Also be flexible. The employer, sometimes individuals say, I want this particular impairment, and the employer says, well, we think that's an undue hardship, but we'd be willing to offer, this alternative. They may not want the alternative. The alternative may not be as effective as what they were requesting, but if it would enable the person to perform the job, the employers complied with the ADA. So I think it's important to keep an open mind. The one other point is just where parents, unfortunately, under the ADA, the individual may be entitled to an accommodation, but a parent of a child with an impairment is not entitled to an accommodation on the basis that this is their child. That said, so there's no legal right to an accommodation, but certainly I've advised parents to, it doesn't mean the employer won't just because they don't necessarily have to. I think that if you go in recognizing that it's unlikely, but it may be worth a try. One other point I want to just address quickly is just there's always risk in going forward. Risk of, as I talked about before, disclosure of confidential medical information, number one. Number two is that, always a risk of retaliation. And again, one of the reasons why I sort of give the advice on how to go about doing so is to not create anger on the other side that may manifest itself as retaliation. So at least and secondly, if the employer is ever going to retaliate, so that's why it's important, I think, to have a paper trail, because if the person says, after I request an accommodation, they retaliated against me, you'll then have some documentation that you made the request. Again, there's just unfortunately, where I have clients who will say, well, I don't want to take, how can I do this without having any risk? You can't. There's always going to be some level of risk. On the other hand, so the alternative is you don't get what the law provides, or you won't. So let's see. So I think that's it from now from me, and we can certainly ask any questions. But now I'm going to turn it back to Michelle.
So, okay, thank you, Gary. The other important aspect of requesting an accommodation is knowing your employer's process. Do they have a process set up? Do you contact HR? Are you supposed to contact your supervisor? Research what that process is. Start with your employee policies and handbook and follow the guidelines set forth in that policy. And as Gary said, you want to put things in writing. This sample letter is going to be available from the Osteogenesis Imperfecta Foundation, but this is a sample letter that I got the overall draft from Equip for Equality out of Chicago. They're a great disability rights organization. I did change it some, but this is basically it. You give your name, what your job title is, the accommodations you're looking for, and then you're requesting it because of COVID, and that you're at greater risk of serious complications due to COVID. So, and as Gary said, it says in the second paragraph at the end, I ask that we engage in the interactive process to determine whether there is an alternative effective accommodation. So, and as mentioned by Gary, and you'll see the link later on, the Job Accommodation Network is in here. Although it says the Great Lakes ADA Center, there are ADA centers throughout the country that cover every region. And so I'm here in Connecticut. We have a New England ADA center. They all have the same phone number. So that phone number is good no matter what section of the country you're in. Just it's not necessary. You could take out Great Lakes and just say ADA Center, free of charge. So that's a good starting point for an accommodation request. And then this is, I drafted for the OI Foundation a sample document you could use to get from your doctor. And this is page 2 of it. And it says, basically tells your employer what an accommodation is and how it's decided. These are several of the common accommodation requests requested for COVID-19. And I'm just going to switch my program that I'm sharing to the actual document. Let's see, medical form. So this is the first page, which is not, it wouldn't copy into the slide well. But as we discussed before, how you are covered by the ADA is important. And you'll see down here, I mentioned most of, everybody with OI has a bodily function that's affected by OI. And, you know, actually I probably should have put bone, muscular skeletal. It's right here. That would be the one you check. It is a substantial impairment of the operation of major bodily function. And then a lot of us will have some of these other ones. OI affects our ability to walk or hear. So you can, your doctor can check those off. And then on page 2, this is what you saw in the slide. And then the doctor can provide any other information that would be helpful, and then they sign it and provide their contact information. So now I'm just going to switch back to PowerPoint. So that's a sample form. Your doctor doesn't have to follow this, but when you let doctors go to just free form, write what they want, they often don't give the employer the information they need. As someone who reviews what comes in from doctors, if the doctor isn't given structure, almost 99% of the notes that come in are useless to me. So I've developed structured forms for the doctors to complete that give me the information I need to process an accommodation request. And so that's why, particularly that first page is the way it's done. And then other tips, keep a diary of what happens day to day with relation to your accommodation request, who says what, who's in the room, who overhears the conversation, just in case you need to know later down the road. Date all correspondence. Doctors are not very good at following up with employers. And I often have, I have employees bugging me, why isn't my accommodation approved? And I say, well, it's being held up by your doctor. So follow up with your doctor to get them the information to the employer that they need. And then again, the OI Foundation will have those sample documents available for anybody to use. So now, Michael, do we have any questions?
Yes, so first off, I want to thank you so much for speaking. You covered so many really important topics. Thank you, Michelle and Gary. We had a number of questions actually come in from the audience before the session even started. So I'm going to start off with some of those questions first, and then we're going to transition to some other questions that we've gotten so far. And again, if you have any questions for our speakers or for the OI Foundation, feel free to type them into the chat bar, and we will get to as many as we can. So one question we had, and I think this is a good starting point for us, is because it's not directly related to the topics you were covering today, but I still think it's an important question, and actually one that we got, for instance, at the last OIF virtual conference in July, was around disclosing your disability or disclosing your OI in sort of like before getting the job. So the question is, when do I disclose that I have a disability, and how much do I tell a potential employer? Which I know is not the exact topics covered today, but I thought was related and important.
Yeah, I can respond quickly. The first, during the, the way the ADA is designed is really a two-step hiring process. At the initial stages is an employer can't ask about any type of medical condition or impairment. The employer may be able to do so after they have extended what's called a conditional job offer. That's often, certain jobs where there's physical requirements. But as a general rule, if is not to disclose anything until after the person's been hired. And to do so for a reason. I always say to clients, unless there's a reason to disclose anything, don't disclose it, because you don't know, the impact it's going to have. But certainly, if he or she needs an accommodation, that's a reason to, the most likely reason to disclose.
Yeah, so if you're in a wheelchair and you're going for an interview, certainly ask if you can interview in a wheelchair accessible location. I mean, that you don't have a choice. You don't want to show up at an interview and find out you can't get in. So those types of requests, you do have to tell somebody.
Right.
Yeah. No, I think that makes a lot of sense. Thank you. So some other questions we got on this topic of accommodations are, and some of these questions I know actually, so since hearing your full presentations, I know you sort of have either directly or indirectly answered some of these questions, but I still think it's important to ask so that we really sort of make it super clear for people. So one is, what are the best practices for requesting accommodations? For me, I'm going to try to answer this first, actually. I actually think, Gary, you had the slide, good faith and interactive process. To me, that sort of sees like kind of the starting point for the requesting process. Are there any other sort of big takeaways as far as best practices?
Well, I think really those are just based on having, looked at cases and been navigating this arena for like 30 years are really each of the ones I listed. I don't think there's any ones that are more or less important. I think they're all important, and all kind of best practices.
Writing is always good. Doing things in writing so that everybody doesn't misinterpret what you're asking for. So try to be as clear and concise as you can and do it in writing. You know, I'm not a big fan of email because sometimes they get lost, they go into spam filter, you know, that would concern me. But, you know, certainly it's an avenue to use. You could email it and then follow up a day or two later to make sure that they received your email, just to be thorough. But I particularly appreciate when employees start by doing something in writing, because it's clear to me what they're looking for.
Got it. No, I think that, you know, you bring up a lot of really good points, this idea about just like when in doubt, get everything in writing, and also keeping the ball moving, so to speak. I think that is very practical and great. So the next couple of questions I have are basically, I would kind of phrase them as scenario based, and I'm going to either read them word for word or lightly paraphrase them. So one is, this person, so say you have type 1 OI, and so they don't use any mobility devices, and they live in Florida, and they present as non-disabled, as many people with type 1 OI do. What are their rights to accommodations, and does it change at all from what you said?
Well, if you're requesting a COVID accommodation, because arguably somebody with type 1 OI who has a genetic impairment of the lung tissue as well as bones is going to be at higher risk for COVID. Doesn't matter if you use a wheelchair or not. If you have OI, you are going to be at higher risk. So I think you need to forget about the type so much, but if you think you need the accommodation, then you do need to make the request and disclose. And as Gary said, when people don't know you have a disability and you disclose it, there is a certain amount of risk in that. But given in certain communities where COVID is spreading significantly, that may be riskier to your health than disclosing to an employer. So I don't know, Gary, if you have anything additional.
No, I agree. There's nothing I can add. I think that's good advice.
Great. No, thank you so much. So the next is about, this person says, I'm concerned that if I submit my accommodation request and it's denied, I'll be positioned as unreasonable. And what advice do you have on how to handle this?
Part of this is, you know, my advice always to clients in this situation is that, again, getting back to, there's some risk. You can't control how other people react. And so if that's what somebody, you know, to balance, what is the, you know, what is the health risk of not disclosing? If you're seeking an accommodation, you have to disclose. Is that, you know, it's kind of, it's going to require acceptance of risk. You can't control that some people might see you as unreasonable. You know, I mean, there's just from a practical human standpoint,
yeah,
that, you know, sometimes when people make requests, it creates friction. I don't think, at least the experience I've had with clients, that's not been the case, but I can't say that's never been the case.
Mm-hmm.
The other thing that people need to know is that when you make an accommodation request, your employer cannot, by law, tell your coworkers unless they are needed to make the accommodation happen. So it's not like they can tell everybody in the office what you've requested. And if they do that, then they have a whole different liability problem than rejecting an accommodation request. And that's why Gary said to put on everything personal and confidential. It reinforces that that is not your accommodation request is not fodder for office gossip. It is a serious medical information that needs to be held closely by the employer and cannot be put in your personnel file, so that when they're considering you for promotion, there's not information about your health in that file. So that's something to keep in mind as well. Hopefully, eases your concern.
Yeah. Thank you. So I guess related to that previous question is then, in what instances are jobs able to legally not accommodate you?
Well, I've been doing a lot of that. Because I decide the accommodations, you know, there are some jobs where if you're a police officer or a 911 dispatcher or other things, we can't survive without you, and we'll take safety measures in your work area to cut down on your risk of COVID. But teleworking is not an option for some jobs, as Gary said in the beginning. And I think you need to look at your particular job. You certainly can request leave as an accommodation, but remember that's probably going to be unpaid. And you're probably going to have to pay for your medical benefits while you're out on leave. So, you know, that's not doable for a lot of people. You know, so Gary, you might have more to say.
No, and I think, you know, it all depends on the nature of the job, you know, because the response varies, just really depends on, you know, I always think the best way to look at essential functions is, what is the reason this job exists? And can the person do that job with an accommodation? You know, and so, for example, I'm dealing with issues with teachers right now.
That was my next question.
Okay, well, so a big thing with teachers, or some school districts, I won't name any particular ones in Connecticut, but they just say no remote teaching. Blanket rule, which is always a risky thing to do, I think, for employers. And so I have to show ultimately that my client, in a case I'm going to be filing, can do the job that is required of a teacher to do, you know, instruct students to do so remotely. You know, I think those sorts of things are coming up often. So a lot of this is, you know, particularly issues surrounding remote work, is we're in a new arena. We'll have to see how it shakes out. I have to do the best job I can advocating, and but at the same time, you know, as Michelle said, there are a lot of jobs that just can't be done remotely, or even with accommodations, the individual can't do the job.
Got it. And it's interesting. So we got a question almost exactly on that topic you were just discussing, particularly around schools. This person was a guidance counselor, but I imagine it's the same argument, teacher versus, because like there are districts doing blended learning, doing alternating schedules, or we're just doing fully remote. Interesting. Okay, thank you. So some other questions I had, and then we're going to start jumping into some of the other questions we got from the chat so far, is has to do with kind of forward thinking. So fast forward to, let's say, February or March 2021, knock on every piece of wood in your house, but there is a COVID vaccine approved by the FDA, and it is now out in the public and people are beginning to take it. In that environment of a COVID vaccine being out in the public, but say it's not available to everyone, there's a wait list, not everyone's taken it, some people have, some people haven't. does these rules around accommodations change at all in regards to COVID-19?
My sense is in the short term, they won't. Because to me, it's no different when the vaccine's available, ideally it's going to reduce the number of people getting it, but it's not going to, eliminate. Here in Connecticut, where the past few months have been very, we've had, a test positive rate of below 1%, whereas in Iowa yesterday, the test positive rate was 20%. So you have huge disparities. I think that those sort of disparities are going to continue regardless of when the vaccine's available. And but the requirements of accommodation, the risk is still there regardless of the nature of the whether a vaccine's available. Now, and again, obviously we're just sort of forecasting when one's available. Maybe next fall, 2021 or something where it's become much more common. Maybe then it starts to change the equation, but I don't think early 2021, even assuming the vaccine's available in February or March, that it's really going to change any of the issues we're navigating right now.
Okay, thank you. So in our last few minutes, I'm actually, Michelle, if you don't mind, I'm going to stop the screen sharing only so that if people want to type in one last question, it more easily pops up. And I'm going to go to speaker view, if you don't mind.
I had one more slide, Michael.
Oh, you did? Oh, I'm sorry. I'm jumping ahead. Go for it if you want to reshare.
I just wanted to, this is helpful resources. To find an employment lawyer like the wonderful Gary Phelan, you can go, there's a national organization called the National Employment Lawyers Association. I screwed up actually. I really screwed this up. National Employment Lawyers Association. I'll fix this in the final version, but this is the right website. Just
Yep.
I wrote it out incorrectly. And then these other resources, of course, Gary mentioned the Accommodation Network. The EEOC has a great COVID resource. And I mentioned that I got the sample letter from Equip for Equality. This is their employment page. And then if you have more general disability rights questions, every state has a disability rights organization, and you can go to the National Disability Rights Network to find the organization in your state. So I will fix that name piece and before it goes out for the good of the group. But there you go, Michael. You can.
Oh, thank you. So we're at 3 p.m. now. If people have one last question, you have about 30 seconds to type in a last question. Otherwise,
Michael, can I ask one question that was in the chat that I thought was a very good question?
Oh yes, go for it.
Yeah, there was somebody had asked, which I thought was a good question. Why should I be, kind of the one who's tolerant when an employer's ignorance?
Yeah.
An employer's response is ignorant, and that they, I'm the one that needs the accommodation. It's a good question because I've had a lot of, clients who experience this. What I always remind them is that, it's the process is a means to an end. What you want is an accommodation. And so if the frustration, if tolerance is going to help you get to that ultimate objective, that's what is going to help. But the second thing is again, under the ADA, it's not the employee who decides, even though it's the employee who needs the accommodation. Under the ADA, ultimately, it's the employer that makes the determination of whether or not what if any accommodation is going to be made. Now, if it turns out that, the employer, the employee believes that the employer violated the ADA, they have that right to file a claim. But ideally, one of the things I've learned early on in this profession is a good job, is better than a good lawsuit. So if it means sort of putting up with something in order to get the accommodation, that's better than having to go to somebody like me hire somebody, file a claim, potentially lose the job.
Great, thank you. And, you know, it kind of highlights too that, like, it just seems like, unfortunately, we're dealing in this world of compromises as well as dealing with this is a fluid situation. Cool. So I want to thank you both again for joining us. To those still on the call, so we will be sending out some of the resources that Michelle and Gary have referenced. We'll be sending out to everyone who signed up for this. We already have your email. We're going to be emailing you all some attachments that they've talked about. So both that sample doctor's letter as well as the accommodation letter as well. And some of the links that we've shared, we're going to package them up nicely for you as well so that you don't miss anything, because I realize so much information has been shared that's going to be really helpful for people. And I want to thank you again so much for joining us on this call, and we hope you stay well and healthy.
Thank you.
Great. Thank you, everyone.